Hey there, welcome back. Today we are going to do something different and review an exam that I took in 2020 for the California Baby Bar. If you have never heard of it, the Baby Bar is an exam given by the State Bar of California, but its official name is the first-year law student's exam. Just like the general bar exam, it's given twice a year but only covers 3 subjects: torts, contracts and criminal law. The 4 essays take place in the morning and then in the afternoon session. There are 100 multiple-choice questions which are designed to replicate the full bar exam. Each time it's offered, one of these topics is tested twice for a total of 4 essays, with each designed to take 1 hour to complete. This time in the tort section, the essay was based in the area of product liability. Products had not been tested in a while, so I did an extra prep session for it just in case, and even though my final essay was not great, I was still able to get an 80%, which, of course, I happily accepted. To help others get their best possible score, I'm going to show you how I did my prep, and then walk through the essay to show you one way that this exam could have been tackled. Everyone that I study with knows that I am big on organization. I think law school demands that you develop your own organizational style that best helps you not only digest and recall information, but also how to structure your answers. So what I did, was one Saturday afternoon, I sat down with all my study guides, outlines and notes and compiled my official mini outline that I could easily memorize. I decided I needed to have a good prima facie description, a few major headings, and then a few good memory devices for the detail. If I had that memorized, I could then just take the facts from the hypo and build a complete essay. So first, let me show you my outline that I created and memorized for the exam. I think one thing to notice is that each area has a kind of defect. Negligence is defective conduct. So if the facts state that someone did something, it would fit here. If it's strict liability, the defect must be in the product itself. If the promise of the seller is broken, or rather defective, then it's a warranty issue. When others ask where I get my information, in addition to what I get from school, I search all the free options online, but tend to use outlines that are written in a manner similar to how I write. I like simple, easy to understand with lots of examples. When I show you my essay, you can see that I keep it as brief as possible while still hitting all the requirements. One of my issues is that I am a slow typist, which requires that I keep my answers focused and as short as possible. Okay, back to the outline. I list my 3 areas of topics. There are actually 5 areas, but I chose to leave out intentional and then combine the warranties together. I know that if I see a claim based on intentional, which is just a battery, that would be easy to write. As far as the order, I don't remember where I heard it, but I was told that if you handle negligence first, then it's easier to just super back for later areas, but I am not sure that matters. Other sample answers posted on the California Bar site wrote their answers in different order, so I guess it just depends. While I memorize the main outline, this is the actual outline that I will put down when I am taking my exam. It's designed to just list the highlights of each area and serves to remind me of what I consider the most important sections. I will sit at night and practice typing this out while watching TV to make sure I have it down and accurate. I can type it out in about 90 seconds, so it's great at saving time. I type it out once, then copy and paste it as needed. If I do it complete the first time, I know that I have everything I need. Okay, so let's look at the hypo now. Of course, we look at the call of the question first to see where our focus is going to be, so let me show you that. Question 1. On what theory or theories of liability could Alice reasonably sue manufacturer? Discuss. 2. On what theory or theories of liability could Bill reasonably sue the manufacturer? Discuss. I put arrows so you can see where my thoughts are. Based on the term theories of liability, this tells me it's a torts exam. Because the party being sued is a manufacturer, it seems likely it's a products liability case. So now that I have product liability in my head, I'll go to the hypo to do a quick read so I can get an idea of the content. After that, the first thing I will do is put down my 2 headings because there are 2 questions that need to be asked. So we have 1. Alice versus manufacturer and 2. Bill versus manufacturer. Now, I'm going to type my outline under the first lawsuit, and then copy and paste it into the second lawsuit because they are just headings which will be required. If the area is not needed, it's easier to remove later and then I won't worry that I forgot something. To get my head into products, I type out my prima facie case at the top of the first lawsuit. Next, and probably most important, I go through the hypo again and see what facts fit into which areas. As you review, remember that each word is there for a reason. I go through word by word and try to see what each one means. I look at it as a puzzle without a picture to help me solve it. I know that all the pieces are there and it's up to me to piece it all together. It's basically a game of hide and seek and I am determined to win. The examiner are trying to tell me information, but they hide it within the story. As I go, I'm going to highlight which areas I think are important to use for facts, or to prove a point in my analysis. There will be a few areas that might be just informational that I won't use, but then you may feel differently about their use. Remember, there is no one right way to write an essay. In each of the next screens, I will break down each paragraph and how to decipher the words. Let's get started. When you look at this first slide, it seems like I underlined almost every word, but as I said earlier, each word is put into an exam for a reason. If we start with the word manufacturer, that will identify the party being charged, but then we can also see what they do. They make fully assembled bikes and sell them directly to consumers. This line tells us two things. The first is that they are commercial suppliers, which is one of the requirements of a proper party who is a defendant. The fact that they sell fully assembled bikes directly to consumers means that the consumer was not responsible for the bike's construction, which means any defect was present when it left the seller's control. The next line shows that Alice is a consumer, which makes her a proper party for a plaintiff in a product case. When they mention that she bought a commuter bike, they are telling us the intended use for the bike, which may come into play later if the defendant tries to claim misuse. Additionally, they mention that the bike is made of aluminum that is welded. Because we are looking for defective conduct, warnings or promises, we can assume that the welding that was done may not only be a defective product, but there may also be defective conduct. The next part about Alice riding her new bike to work can show that she was using the bike as intended, commuting to work. This can be used to offset a defense of contributory or comparative negligence. When the facts tell us, without warning, the frame collapsed and she was injured due to the defect, this speaks of causation. The sloppy welds were the but for cause in addition to the crash and injuries being foreseeable. The phrase, without warning, can demonstrate that the injury was unavoidable and she did not contribute to her own injuries. When we are told that Alice took the bike to a mechanic to diagnose the cause of the accident, he tells her that due to sloppy welds, the bike crashed. These entire two lines contain a lot of useful information that can be used in several ways. It can be used to demonstrate the bike was in a defective condition when it left to manufacturer. It will also show that it fails the consumer expectation test because consumers would expect a welding job to be done professionally and not to cause breakage. When the mechanic said had never seen such sloppy welds, this could show negligence because the manufacturer knew or should have known the condition because they are under a duty to inspect, discover and correct errors. All manufacturers are responsible for a duty of care to their consumer and any resulting breach which causes damages. So for all those possibilities, I highlighted the whole area. Finally, we can also make a note that when Alice bought a commuter bike to commute to work, she received a warranty that the bike would be able to meet that standard. Additionally, if she told the salesman what she intended to use it for, she may have both implied warranty claims as well as any possible written warranties that a new bike may come with. Okay, that is our case for Alice v. Manufacturer. Let's take a look at Bill's claim next. So here we see that Bill is a proper plaintiff to bring suit because he purchased a bike from the manufacturer. The bike he purchased was a road racing bike, which tells us he has certain expectations, which speaks to both an implied warranty as well as having a consumer expectation. That carbon fiber was used is not an issue, as it's an industry standard, but when the manufacturer reduced the thickness, it caused weakness and breakage. By actively reducing the carbon, the design became defective because they could have had an alternative design that was safer. Further, this design choice fails in a utility versus risk argument because the modification increased the likelihood of injury. Additionally, there were several reviews from industry professionals that warned that reducing carbon can make them weaker and subject to breakage. Because this information was widely known, the manufacturer knew or should have known, which speaks to their liability with a defective promise and product. Finally, we are told that Bill was injured 6 months later and an investigation showed that the reduced carbon was to blame. This investigation will give us our actual cause because the reduced carbon is the but for cause. Proximate cause can be shown because it was foreseeable that reducing the thickness of the carbon made the bike subject to breakage. Bill was using the bike as designed and suffered damages as a result. The manufacturer may claim assumption of the risk, but only if he knew about the reduced carbon and the potential problems. They may also claim comparative or contributory negligence, but most likely, that defense will fail because the bike was used as intended. So as you can see, most of the content in the hypo is used to prove or disprove a claim that we are stating. We can use the underlined facts to show liability and claims for negligence, strict liability and torts and warranties. Now that we have our hypo reviewed and understand how we can use the facts, let's put it all together to create our essay. To illustrate, I went through and added the prima facie description and laid out negligence. As we go through the outline step by step, We will take facts from the hypo to fill in each line where appropriate. Let's start with negligence. We know we need two parts for duty. A standard of care and to whom is the duty owed. The standard of care is that of a reasonable manufacturer and to not put a defective product into the stream of commerce. Now, to whom is the duty owed? The duty is owed to all foreseeable users of the product. Next, we need to find a breach. Here, we can show that a bike mechanic was able to look at the sloppy welds which he had never seen. If a bike mechanic found the welds, it can be inferred that the manufacturer failed to inspect, discover or correct this problem. Therefore, there was a breach. For causation, we need to show both actual and proximate cause. We can state that, but for the tubes not being improperly welded, there would be no actual cause. For proximate cause, we need to show foreseeability. We can show that it was foreseeable that if the tubes were not properly welded together, a crash is likely to occur. With regards to damages, we put them into two types, general and special. We are shown by the facts the frame collapsed, causing her to crash and suffer serious injuries. This will allow Alice to sue for both general and special damages. General damages are for the present and future pain and suffering, and special damages will be for any lost wages or money that was a result of the negligence. Finally, for defenses, the manufacturer may try to use comparative or contributory negligence, but because Alice was using her commuter bike to commute with, these claims will fail. Now let's go to the next possible liability, which is strict liability. I will start with my prima facie heading and include information about proper parties. Recall that under strict liability, you can use either the second or third restatements. I looked at several past exams that the bar posted, but there is no real consensus, so to be safe, I used both. Unless you have a grader scoring sheet, there is no real way to know for sure. If you have this as a classroom essay, it just depends on what your professor wants you to write. Next, I write the rule, and then I also include the consumer expectation test, since that is one measure used to prove that the product was in a defective condition that is unreasonably safe. I add my analysis to show how I have come to this conclusion. As I look back at this exam, I see areas where I would have written it differently, but when you are under a time constraint, it's easy to miss things or leave things out, especially if you are a slow typist and trying to hurry. My analysis was very brief, and given more time, I would have added more facts and been more detailed. For the third restatement, there are 3 sections that we can use. If we can find defects in the design, manufacturing or warning, this is where we can put it. I used a quote from the mechanic to show that we are not pursuing a design defect since it was poor workmanship that was a cause. Under the manufacturing area, we use the facts to show that the bike was not welded properly, which made it dangerous, even when used as intended. The warning defect came in the form of a lack of warning. If the manufacturer had issued a warning that some or all of their bikes have potentially poor welding, Alice may have purchased a different bike or been more prepared for the bike to collapse when in use. To close out this section, we can just use our answers that we typed in previously by using the term supra. I mentioned before that if we do a good job in our initial section, and in this case negligence, we only have to write it one time and then can call back to it later as needed to save time. Finally, we have warranties. Warranties are promises regarding how the product will work and that it will conform to expected standards. In both cases, the implied promises that it was fit as a commuter bike and that it was the same standard as other commuter bikes failed. Therefore, both warranties were breached. Any defense, which we supra back to, will fail. You can now move on to Bill using the same method as we used for Alice. Take the facts from the hypo to fill out relevant sections of your outline. Bill's case had the same 3 types of issues, but the facts were slightly different. Well, I hope this helps you see one way that you can tackle a product's essay or any kind of essay. Get organized, have a great outline, and read the hypo to see what each word means. It might take practice, but the quicker you can learn to analyze each word, the more successful you will become. Thanks for watching. I hope this helps with your studies.